ever really thought about what gives a promise its power? I mean, what turns a simple "I will" into something that's legally unbreakable? Well, today, we're diving deep into the foundation of pretty much our entire modern world, the law of contracts.
To get us started, let's go back in time. Picture a guy named Amrit Lal. He's got mangoes, but he needs rice. So he makes a trade with his neighbor, 10 kilos of his mangoes for some rice. Seems like a simple, fair exchange, right? But then it hits him. It's not mango season. He just gave away something incredibly rare and valuable for a bargain price. He totally regrets the deal.
You see, Amrit Lal's problem really gets to the heart of why the old barter systems just weren't enough. There was no certainty. If we were ever going to build towns, cities, a whole economy, we needed something more. We needed a way to make sure a promise made today would still be good tomorrow. And that, right there, is where the idea of a contract was born.
So here's how we're going to break it all down. First, we'll look at the basic anatomy of a contract. Then, we'll get into the essential pillars that make a promise stick. After that, we'll explore what happens when things fall apart. And finally, we'll talk about the real power behind your word in today's world. Okay, first things first, what is a contract really? It's a concept that's woven into everything we do, from buying a coffee to clicking accept on a new app. The law actually gives us a surprisingly simple definition. The Indian Contract Act of 1872 puts it perfectly. A contract is an agreement enforceable by law. You see the two crucial parts there? You need an agreement, but that's not enough. It also has to be enforceable by law. And that leads us to the absolute golden rule of contract law. If you remember one thing from this whole explainer, make it this. All contracts are agreements, but, and this is a big but, not all agreements are contracts. An agreement is just the starting point. To level up into a real contract, you need a few more key ingredients. You know, you can think of a valid contract like a building. For it to stand strong and not collapse under pressure, it needs a solid foundation and some really sturdy pillars. So, let's take a look at what those pillars are. It all kicks off with an offer and someone accepting that offer. But that's just a start. Both sides have to actually intend for their agreement to be legally serious. Then there's something called lawful consideration. That just means something of value has to be exchanged. Both people have to be legally capable of making a contract, and, this one's huge, they have to agree freely, with no funny business like pressure or lies. Let's dig into that intention pillar with a super famous case from 1919. It's called Balfour versus Balfour. So you have a husband, Mr. Balfour, working over in Ceylon. He and his wife are visiting England, but she gets sick and has to stay behind. He promises he'll send her £30 a month to help out.
Well, as things go, they later separated and he stopped sending the money. So Mrs. Balfour sued him. But the court actually sided with the husband. They said this was just a domestic arrangement, a social promise made between a husband and wife. The crucial point? They never intended to create a legally binding contract. It was a promise, but not one the law could enforce.
Now, for a totally different spin, let's look at another classic case. This one answers a pretty wild question. Can you actually make a contract with the entire world? Back in 1893, a company called the Carbolic Smoke Ball Company put out an ad. They claimed their product could prevent the flu and even offered a £100 reward to anyone who used it as directed and still got sick. And just to show they were serious, they did something that really grabbed everyone's attention. They deposited £1,000, a massive sum back then, into a bank account ready to pay out anyone who made a claim. This wasn't just some marketing gimmick. This was a clear signal that they meant business.
Sure enough, a woman named Mrs. Carlill used the smoke ball, still got the flu, and demanded her £100. The company tried to argue it was just an ad puff, but the court's ruling was a game changer. They established the idea of a general offer. They said, yes, you absolutely can make an offer to the whole world. Putting that money in the bank proved they were serious. And, in a case like this, just doing the thing they asked for, using the smoke ball, was the acceptance. Mrs. Carlill got her money.
Okay, next pillar, consideration. It's a legal-sounding word, but it just means something in return. For a deal to be real, both people have to get some kind of benefit. Now, it doesn't have to be an equal trade, but it has to be a real exchange. For instance, a famous case showed that if you do a favor for someone just because a third person asks you to, the original person doesn't owe you anything. The something in return has to be directly connected to their promise. So, who can even make a binding promise? This brings us to the capacity to contract. The law is pretty protective of certain groups, especially minors, anyone under 18, and the landmark case for this is Mohori Bibee versus Dharmodas Ghose.
The ruling here was absolutely crystal clear, and it set the standard for good. The court declared that any agreement made with a minor is void ab initio. That's just a fancy Latin way of saying it's invalid from the very beginning. It's like the contract never, ever existed in the first place.
Okay, so we've built our contract. It has all the right pillars. But, life happens. What happens when agreements get challenged or promises get broken? Let's get into how contracts are classified and, more importantly, how they end.
Yeah, as you can see, not all contracts are created equal. You have your standard valid contracts, but then you have ones that are void, voidable, illegal, or even unenforceable. Basically, their legal status is what determines if a court will actually step in and make people stick to the deal. Now, two key types to understand are void and voidable. A void contract is a dud from the start, like that agreement with a minor we talked about. It's just not enforceable. A voidable contract is a bit different. It's actually a valid contract, but one person has the option to back out. This usually happens if they were tricked or forced into it. So the person who was wronged gets to decide, do we cancel the whole thing or do we go through with it?
So every contract that begins, well, it also has to end. And that brings us right to the heart of what we're talking about today, the discharge of a contract. It's just the official legal term for how a contract's duties are wrapped up for good.
So what does that legal jargon actually mean? It's pretty simple, really. Discharge of a contract just means that the parties are now free from their obligations to each other. The promise has been kept, or for whatever reason, it just can't be enforced anymore. The deal is done.
So, how does this all happen?
Well, it turns out there are a bunch of ways a contract can end. We're going to look at 6 key paths: performance, agreement, impossibility, lapse of time, operation of law, and the big one, breach. We're going to focus on the most common ones, starting with the one everyone hopes for.
This is the happy ending for every contract. It's the whole reason you make one in the first place, right? Both sides do exactly what they promise they'd do. The deal is done, everybody walks away happy, and the contract is officially discharged.
It really is as simple as this. Party A gets their money, Party B gets their new dining set. Promises were made, and promises were kept. The contract served its purpose, and now it just dissolves. It's complete.
But hey, what if things change? Life happens. Well, people can also just mutually agree to call it quits. This can happen in a few ways, like with novation, where you swap the old contract for a new one, rescission, where you just cancel the whole thing, or remission, where one person agrees to accept less than what they were originally owed.
Let's look at remission for a sec. So B is owed 5,000 rupees. But maybe A is having a tough time. B agrees to just take 2,000 as the full and final payment. By accepting that smaller amount, the original contract, the original debt, is legally wiped clean.
Now for a more dramatic ending. What happens when something totally out of the blue, something completely unexpected, makes it literally impossible to fulfill the contract? In law, this is called supervening impossibility. It's when some outside event that's nobody's fault just completely wrecks the whole agreement.
A perfect example. Say the thing being sold is just gone. You can't sell a car that's been totaled in an accident, right? The car no longer exists. In that case, the contract is just automatically discharged. Its entire purpose has been frustrated. Poof, it's gone.
So we've seen how contracts can end neatly through fulfillment or by mutual consent. But what happens when things really go wrong? This brings us to the messiest, most contentious ending of all, breach of contract.
A breach is, plain and simple, a broken promise. It's when one person, without any good legal reason, just doesn't do their part. That failure shatters the contract and, crucially, gives the other person legal options.
You see, a breach isn't just the end of the line. It's the start of a whole new process. The law, as you can see right here in the Indian Contract Act, gives a clear path to justice. Basically, the person who got wronged is entitled to get compensation from the one who broke the promise.
So what does that justice actually look like? When a promise is broken, the law steps in with remedies for the person who was harmed. Let's take a look at the 2 most common ways this plays out.
The legal system basically has 2 main tools in its toolbox here. The most common one by far is damages. That's just cash, money, paid to cover whatever losses you suffered. But sometimes money just isn't enough. In really rare cases, say with a one-of-a-kind piece of art, a court might order specific performance, which actually forces the other person to go through with the original promise.
You know, it's really easy to think of contracts as these stuffy, complicated documents for giant corporations, but the truth? They are the invisible architecture that holds up our entire modern world.
Think about it.
We have come such a long way from the guesswork of the old barter system. Today, we enter into complex contracts with a single tap on our phones, often without even giving it a second thought.
Those same basic ideas that governed Amrit Law's trade of mangoes for rice have evolved to manage our incredibly complex digital lives. The law of contracts is what gives us fairness and predictability. It's the bedrock of pretty much everything we do.
Because at the end of the day, a contract is so much more than just a piece of paper or a digital file. It's a legally binding promise. It's the world's way of saying that in the eyes of the law, every single promise you make carries real, serious weight.
And that brings it all right back to you. Understanding how these promises begin and end isn't just for lawyers. It's about seeing the incredible web of agreements that shape our lives every single day. So take a second and think about it. What promises will you make today?